I'll ask a couple of questions. You mentioned patentable versus proprietary. Can you kind of explain what the proprietary is in relation to patentable?
Sure.
And then your last example of the programmer who wanted 25%. If you take your project to a developer, how do you approach them so that you don't run into that problem? Is it more like just paying them, you would have been better off, assuming they're not partners, just paying and getting the intellectual property?
I've got answers for both of your questions. The second question related to how do you pay a programmer? You really have to convince that programmer of what your pre-money value in the company is. So that's why I talked about pre-money value before we got into the employment discussion. If the programmer believes the company is worth $2 million today because of all the things you've done up to now, the team you put together, the business plan as far as you've gone with it, your potential for raising capital, your track record, the track record of the other people in your company, then he has to do $100,000 worth of work. He'll accept 5% of stock or maybe 2.5% and cash for the balance. And you negotiate that. Programmer should not own half of your company. And I have people come to me where they want to give half the company to a programmer. That role is there are a few companies where the programmer is the company, but that's very rare. Usually a programmer owns a few points. If you can, you pay the programmer rather than giving them any stock or a very small amount of stock. But if you don't have any money and they have to get involved, you have to look at it and say, okay, how much can I afford to give away in the company to the programmer and still keep enough stock to cover every other person I have to cover and then have enough stock for me? And you sit down with your cap table, a listing of the people you're going to get involved in the company, and you say, how much stock am I going to have to reserve for each of these people and make sure I have enough? I mean, I had a client who raised $50 million for his company over 10 years on 5 different rounds of financing. And every time he went out to raise money, he didn't get a high enough value. The company went public after 10 years at a valuation of $250 million, and he owned 2.5% of the company. Now, better to make $6 or $7 million than nothing. He was the CEO the whole time. He should have owned a lot more of the company by the time it went public, and he didn't because he had to give away too much at each level to keep the company going. So the issue of how much do you give any given person, you make a schedule. I have a client who's about to sell his company for $200 million. I mean, it's an incredible company. I can't tell you more about it other than it's 3 years old. And they've got a list of buyers one of them will buy the company. And he's got about 110 employees. About 10 of them are management. And each of the management guys, he sat down with them and asked them how much they think they should get. Well, if he gave everybody on the team what they asked for, he wouldn't get anything. And so he has to sit back and say, okay, I'm going to give 20% of the proceeds of this sale to my entire management team. Me and my founding partners are going to get the other 80%. And then he has to take that 20% and break it down. Now, the good part is he hasn't made promises to anybody. The tough part is probably most of those people are going to be a little disappointed even if they get a check for $1 million because they wanted a check for $2 or $3 million. And it's something that he didn't handle early on, even though I asked him to handle it and I talked to him about it. Luckily, he didn't make any commitments. He has total control over it. And he has to figure out politically how to make everybody happy without anybody going crazy or going sideways on him. Okay, now that I've answered the second question, I forgot the first question. Can you run it by me very quickly again, just from your seat?
Proprietary versus patentable.
Got it. Very good question. When you've got a new idea and you think it might be patentable, you talk to engineers that you know, if you can, do you think there's something patentable here? if they think there might be something, you talk to people like me. I've seen lots of things that get patented and lots of things that aren't patented. And you run the idea by us, and we'll say, yes, it might be patentable. Then what you do is you go to a patent attorney, and there are several of them who every university has 4 or 5 of them kind of hang around the incubators. I'm sure you know who their names are, and you find one that you really like who will, for a very low fee, do a patent search for you, $1,000 to $1,500, and you find that somewhere from friends and family, and they do the search and they say, you know something, this is patentable, or you know, you really aren't going to get a patent on this. And if you're going to get a patent on it, you apply for a provisional patent right away. It costs about $3,000 or $4,000. You've got a year to perfect it, but at least you've got a leg up. And when you go to your investors and the rest of your management team, you can say, we have applied for a provisional patent. Even if you might not eventually get it, it shows that you're thinking about protecting yourself. If it's not patentable, you want to keep as many pieces to the puzzle proprietary to yourself. When you hire people to get involved on your team, not only do they sign NDAs, they actually, which are really not very enforceable, they sign employment agreements with you that have trade secret provisions and confidentiality provisions in them that are very carefully written, so that when they learn things while working for your company, they cannot take them someplace else without subjecting themselves to a lawsuit. Now, you see those lawsuits all the time in Silicon Valley, where a key engineer leaves one company, goes to another company, takes the company secrets with him, and the company he used to work for files a lawsuit. I've seen one a year for the past 20 years. Those happen often. And to protect your information and keep it proprietary, you have your people who are working for you sign an agreement that says that they're working for you, that the things they're going to learn that they didn't know before belong to you, and that they're going to keep them as trade secrets and confidential and not tell anyone else about it unless you give them permission to. Now, you can't take away knowledge that they had before, but you can certainly control the knowledge that they learn while they're working for you. Incidentally, non-competition agreements are not enforceable in California. So if you have an employee working for you and in his written agreement, it says you can't work for a competitor, you can enforce that while they're working for you. But as soon as they leave you, they can go work wherever they want to work. Now, can they take these trade secrets or this proprietary information? As long as you've documented it carefully and you have a signed agreement from them, they're subjecting themselves and their new company to a lawsuit. We have one of those going on right now. Somebody's been working for us, for one of my clients, for about 6 months, and he has learned a lot of stuff from us, and he is making a decision whether he wants to work for us or go to a competitor. And we've told him if he goes to a competitor, he's been our employee, we've paid him a lot of money, he signed a trade secret and a confidentiality agreement. Anything that he learned while he worked for us, he can't bring to somebody else, or we'll sue him and his new boss. Back to proprietary. If you trademark your names, get all the URLs surrounding your name. And sometimes I'll have a client with a beautiful name, and they'll go to reserve the URL. Somebody else has already taken it. If you're a brand new startup, change your name. Or if you can buy it for $1,000, do it. But I've had clients go out and spend 6 months on a name, finally go out to meet with me, and that day go out to get the URL, and somebody wants $20,000 for it. It's a wrong place to put $20,000 when you're first starting a business. So proprietary versus patentable, you really need a patent attorney to make that final decision for you. A patent attorney is an engineer most of the time, and they're a lawyer, and they know you try to find a patent attorney who's already worked in your field, so that they don't have to do as much research and they can give you the best input. Example, there are attorneys who are really good at software patents. There are attorneys who are really good at engine patents. There are attorneys who are really good at hardware patents. And there are attorneys who are really good at medical patents, both for hardware and for inventions, new inventions, and biological inventions. And you'll want to find an attorney who's best at it. 25 years ago, my brother started a company to build reusable rocket ships. I spent 2 months finding an attorney who knows how to file patents on rocket ship engines. And we found a law firm in Texas that had filed patents on rocket ship engines for other companies and didn't have a conflict of interest, and we hired them to file patents for our company. By the way, there's something called patenting on the fly. I've used it a number of times in companies where the patents were make or break. My brother started a company in the early 80s to put tourists into space. It sounds a little crazy, but the idea of the company was converted to a module that's 10 feet wide and 13 feet around that fit in the cargo bay of the space shuttle to carry scientific research into low Earth orbit and to carry supplies to the International Space Station. My brother was an engineer. While he was designing this module to fit in the cargo bay of the space station, he had to follow a whole series of rules that NASA put out in order to get cargo in the space shuttle, because the space shuttle can't carry things unless you follow the rules. One of the rules was the astronauts had to have the ability to crawl into the cargo bay without opening the cargo bay doors in case they jammed. So my brother took this round module that was to fit inside the cargo bay and flattened the top. He put a crawl space on the top of it. We filed for a patent on that. Along the way, he realized he could engineer flat end caps instead of hyperbolic end caps, which they were using up to now, partial circles to handle the pressure of takeoff and reentry. You could do it with a flat end cap in the early 80s, the same way they designed stadium domes, where they have structures built underneath them so that it doesn't have to be in a circular shape. We filed a patent on that. While we were raising money for our company, we met with Rockwell Corporation, asking them for $30 million. And we give them 10% of the company. We had this big meeting, and they said, we'll give you the $30 million, but we want 90% of the company. And my brother got up with a smile and walked out of the meeting, 20 minutes into an all-day meeting. And they said, what are you doing? And he said, I'm going to find the money someplace else. And they had already looked at our information. And what they did was, when we bid with NASA for a $184 million contract to fly in the space shuttle, they spent 2 years designing a competing aircraft to ours, using our flat top and using our flat end caps. They were ready to submit their bid to NASA. One of the things we did is we paid for everything we did with our own money. We didn't use government money, so we owned the patents. Normally, when the government gives you money, you can own the patents, but they get to use them wherever they want. Well, Rockwell Corporation thought that because the government was involved, that they could use our patented technology. We connected with them, let them know that we owned the patents, that we paid for them ourselves. They were not government funded. And if they filed a competing bid, we would sue them. Now, they had spent probably $10 or $15 million designing their own version of our vehicle, and they never submitted their bid. We won the bid, $184 million bid. With that, we raised $250 million. We went public. The Space Hab module flew in the cargo bay of the space shuttle on 18 flights, supplying the space station and doing low Earth orbit research. By the way, if you go to USC, the California Science Center, where the shuttle Endeavour is on display, right next to it is the Space Hab module, the surviving module. We actually built 2 of them. One of them went down with Columbia. Okay, let's go back. So patents are important. If we didn't have our patents on the fly, paid for by us, we would have been out of business. We could not compete with Rockwell. It was a multi-billion-dollar company, but our patents saved us. Now, can you do patents on the fly? Yes. Is it expensive? Yes. So you have to have a lot of money to be able to do that, or a patent attorney who's willing to work at a big discount for some stock in your company. Does that answer the question on proprietariness versus patents?
Yes.
Is there an add-on to that? Okay. So let's step back now. When you go to bring on more people, oh, by the way, every employee is an at-will employee, including the CEO. And a lot of people come to me and say, I want to have a guaranteed 5-year employment agreement at $200,000 a year, or I'm not going to go out and raise money because I don't want them to fire me. Well, the reality is they won't raise their money if they have that kind of an agreement. Everybody winds up with employment agreements, probably 1 or 2 year, sometimes 3-year employment agreements, but the board of directors has the right to terminate you. Now, if you're really powerful and you're really good and you're one of a kind, you can say you can't terminate me unless it's for cause. But generally speaking, the founders aren't in that role, and you all sign what's called at-will agreements, and you get paid and you earn your stock as long as you're with the company. Now, here's a reality check for everyone. There is something called an entrepreneurial cap. There are books written on it. There's a professor at UCLA who made a living for 30 years writing books and giving courses at UCLA in their MBA program on the entrepreneurial cap. And what it is how far you, as a founder of a company, can take that company. When a VC or a private investor or a hedge fund sits down with you and your team and asks you questions, they are judging you on how far you can take the company. I know, because half the time I represent the money side. The other time I represent the entrepreneurs. So I've been on both sides of the track. And what happens is they'll meet a young entrepreneur who's very aggressive, who's building a young company. And after the meeting with him, to themselves, they'll say, this guy could probably take it to $10 million in sales. But as soon as we had 10 million in sales, it's a whole different structure. It's no longer an entrepreneurial company. We're going to need to bring in a new CEO at that time. And they design their paperwork so that they have the right to do that when it's necessary. And I tell my client, I said, hey, expect these guys to remove you at some point when the company gets to 10 or $15 million in sales, unless you can really grow big time. Now, most of the time, it's really hard to do that. We've had 6 companies where the founder of the company in our office was the CEO when the company did an IPO on NASDAQ or the New York Stock Exchange. 6 companies out of 4,000. So the probability of you as a founder to staying the head of your company all the way through is very small. I mean, you read about them all the time, and you could tell me 10 companies right now that you've seen it. You know, there are 7 million companies in the United States, and a few dozen of them have gone all the way up, and a few of those had the same CEO that they had when the company was founded. It's a very small group. Don't expect to be in that group, but do expect to ask your investors, when do you think the company will outgrow me? Because I'm going to try to get past that, because I want to be in charge of this company as long as I can be. But you have to be able to say to them, if you're going to have them invest with you, you'll help me know when the company's outgrown me and I need to bring in other people. Now, if you can hire really good people around you and learn very quickly, you can go all the way. But if you can't, and the company needs more, you're one of the people who wants to replace yourself. So understand what your entrepreneurial cap is. Ask your investors about it. Ask your management team about it. Not like you aren't good enough, but like you are good enough to know that at some point you may need to be replaced. When someone comes into me and said, I'm going to be the CEO forever, I don't want to represent them. I had a really cute story. In the mid-'80s, I had 3 little kids at home, and one of my potential clients brought me a new toy that was made. It was in the box, and he said he's going to sell them at Christmas time. It was March or April, and they were being manufactured in Taiwan, and he wanted to go out and raise $400,000. And I said, what's the $400,000 for? And he said, that 400 grand, I've got 10,000 being made in Taiwan right now, and I'm going to bring them over, and so they cost me $40 a piece. And I said, that's your 400 grand. He said, that's right. And I'm going to sell them as soon as they come in, and I'm going to sell them for $80 a piece, and I'm going to make money, and I'm going to build my whole company around that. I said, wait a minute. For somebody to invest 400 grand in your company, you need some infrastructure. You need to have a financial guy. You need to have a marketing guy. You need to have a facility to store the toys and to ship them out and to bill and accounts receivable and collections. And I did some of my own calculations, and I said, you need $2.5 million. He said, I don't want the $2.5 million. I just want to get $400,000, enough to buy the goods, because when I bring those goods over, all the toy companies are going to line their trucks up at the docks and give me cashier's check for my toys. And I said, that happens once every 10 years. Usually you inventory the toys, the stores buy them. If they sell, they buy more, and Toys R Us pays you in 60 days. You're going to have to carry accounts receivable. And he said, I'm going to sell them at the docks. I said, I can't raise money for you that way. I said, I'll tell you what I can do. I've got an investor who's in the toy business. He'll put up the 400 grand for you. But the documentation will read, if you need more money, you go from owning 51% to owning 10%. And you go from being the CEO to being the CTO. You're in charge of developing new toys. And he said, I don't want to do that because I want to stay the CEO. And I said, I can't raise your money for you. He called me back every day for about 6 weeks at 6 in the morning because he knows I'm in to this day at 6 in the morning. And he said, you have my money? I said, yes, $2.5 million. And they're going to want to own 70% of the company and give you 30%. Eventually, you're going to get reduced down to 10% when they raise more money. He said, I won't do that. He stopped calling me after about 6 weeks. He brought his toys in before Christmas time, late October. Sure enough, the tricks lined up at the docks to pick him up and give him cashier's checks. The toy was a doll that I brought home to my kids, my young kids who were 4 or 5 years old, to play with. 4 or 5 year olds play with the toy for 10 minutes and go to the next toy. My kids played with this toy for 3 hours. Teddy Ruxpin, the first talking doll. It was a little doll that the eyes moved and the mouth moved. You put a cassette in its chest and it read a book to you. And Worlds of Wonder became a $130 million company, but not with him as the CEO. He got his $400,000 from somebody else. Within 6 months, they took over the company, put him the head of technology, gave him 10% of the company. And the company lasted for about 5 years until there was no proprietary technology. Disney had the technology. The inventor who brought it to me worked at Disney, brought the technology out because it wasn't patentable. And other people started making the toys with Disney characters instead of Teddy Ruxpin characters. They took the market away from them. So what's the lesson? You have to build a management team. He didn't. You have to understand where the money is going to come from and how to get it and what it's going to take to get the money. And that's a thoughtful process, which includes your business plan, the right management team, and raising a little bit of money at stages. So at the beginning, you raise your first 100,000, then you raise your next million, then you raise your next 5 million. And each time you give away more of the company, but at a much higher valuation so that you don't wind up with nothing left. Like my client who built the database engine and wound up with 2.5% of his company.